Welcome to UWM's Fair Credit Reporting Act training. Applying for a loan, such as a mortgage or a job, typically involves having a credit report pulled or a background check. These are both examples of what's called a consumer report. Examples of which include credit report, background checks, and any other written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's credit, character, general reputation, personal characteristics, or mode of living, which is used as a factor in considering a consumer's eligibility. The Fair Credit Reporting Act, passed in 1970, ensures that consumer reporting agencies, known as CRAs, act reasonably with respect to consumer information in regard to confidentiality, accuracy, relevancy, and the proper utilization of such information. Under the Fair Credit Reporting Act, a CRA may only provide a consumer report for certain permissible purposes, including in response to the order of a court with appropriate jurisdiction, by consumer written consent or instruction, for employment purposes, for use in underwriting insurance, there must be a legitimate business need for the information, and for use in connection with credit transactions. Brokers and correspondents should obtain permission during the application process to pull a consumer report, and it should be documented. As a best practice, it's recommended that the borrower provides a written authorization to pull credit. The three big consumer reporting agencies utilized for credit reports are Experian, TransUnion, and Equifax. When reporting information to a CRA, some guidelines must be followed. Provide information that is accurate and complete, and also investigate consumer disputes about the accuracy of information we provide. If for some reason inaccurate or incomplete information is sent to a CRA, promptly notify them and provide the correct information. In addition, the consumer has the right to dispute the accuracy of the information provided to a CRA. The consumer can do this by either submitting a dispute to the CRA or to the creditor directly. Negative information is required to be reported, including delinquencies, late payments, insolvency or bankruptcy, or any form of default. Anytime negative information is reported on a consumer to a CRA, the consumer must be notified of the reporting by mail, either before the negative information is provided to the CRA or within 30 days of providing it. Also, if the CRA notifies the reporting agency that someone's identity has been stolen, the following steps must be followed. Having procedures in place to prevent re-reporting the information. If a debt, such as a mortgage, results from identity theft, that debt cannot be sold, transferred, or placed for collection. If the consumer notifies the creditor that they are a victim of identity theft and provides an identity theft report, the reporting agency can't send information to a CRA regarding the fraudulent debt. If the reporting agency reported inaccurate information due to identity theft, they must promptly notify each CRA of the correct information. And lastly, transaction records are required to be supplied to the identity theft victim or law enforcement officer. Running background checks during the hiring process is also obtaining consumer reports. And when using these reports to make employment decisions, there are also compliance standards that must be maintained through FCRA. Before a consumer report can be pulled for employment purposes, the applicant must be told through written notice that information in the report might be used for decisions related to their employment, get written permission from the applicant, certify compliance from the company for which the information on the applicant is coming from, and before any adverse employment action based in whole or in part on the information in that report, the applicant must be given a notice that includes a copy of the consumer report that was relied on to make the decision, a copy of their rights under the FCRA. Then, once an adverse employment action is taken, the person must be given a notice of that fact. And once usage of the consumer report is complete, it has to be securely disposed of along with any information gathered from it. The Federal Trade Commission and the Consumer Financial Protection Bureau enforce the FCRA. If they find any violations of FCRA, they are able to impose financial penalties. Thanks for watching.